time in court. My name is Heather, and this is the latest filing that's come out in the Delphi case. So I just went over a couple things yesterday. We now have a trial date set, which is May 13th of this year. So that's good. We don't have to wait till October. The victim's family members don't have to wait till October. So hopefully, things go as planned and we move along with that May 13th date for a trial. However, I think she only scheduled it for 3 weeks. I think this is going to be a lot longer, but we'll see. All right, so the latest filing that has just come out, as you can tell by the thumbnail, is the defense attorneys have requested sanctions. So this is a motion to compel and a request for sanctions on Nick McLeland. So let's get started here. Now comes the accused Richard Allen by and through counsel Andrew Baldwin and Bradley Rosie, and moves this court to compel the state of Indiana to provide certain discovery that the defense believes exists, but that the state of Indiana has not provided to the defense. Additionally, the defense seeks a sanction against the state of Indiana for a variety of discovery violations detailed herein. The sanction requested is simply that any delay in the trial created by the state's violation of rules of discovery be assessed against the state of Indiana. So all this time, this delay, we want you to look at that and sanction the state for delaying trial. In support of said motion, the accused states the following, and this is coming from Rick Allen, but from his attorneys, but really the attorneys know this best. So, number 1, the defense has attempted to cooperate with the state of Indiana in order to comply with the spirit of Local Rule 08 CR 0018, which is attached and marked as Defense Exhibit A. We don't have the exhibits, unfortunately. We just have this document, which is 18 pages. So I'm going to try not to interject too much and read along so we can get through it. All right, so it's attached for, Exhibit A is attached, but we don't have it. Pursuant to the local rule, the state of Indiana shall disclose and furnish all relevant items and information under the rule to the defendant within 30 days from the date of the appearance, subject to constitutional limitations and other limitations, and the defense shall provide the same within 30 days of the state providing its evidence. Number 3, pursuant to said local rule, the party seeking disclosure of evidence shall include in the party's motion or request a statement showing that the attorney making the motion or request has made a reasonable effort to reach agreement with opposing counsel concerning matters set forth in the motion or request, including date, time, place, and manner of this effort to reach an agreement. To this date, the state of Indiana continues to provide late discovery of items and information that is required to provide no later than December 14th, 2022. Not last December, the December before that, pursuant to local rule. Number 5, for example, we get examples here. For example, on February 20th, 2024, the defense sent a certified letter to the prosecutor's office seeking many pieces of evidence, over 20, that the defense believes exists, but it appears that the state of Indiana has failed to turn over to the defense. Number 6, in that certified letter, the defense requested a determination of if said evidence exists, and if so, to determine if that evidence has been turned over to the defense, as the defense was unable to locate any of the aforementioned evidence. So we just want to make sure, did you send it to us? Let us know. We want you to let us know in a certified letter, whatever he said, to determine if that evidence has been turned over to the defense, as the defense was unable to locate any of it. due to the vast amount of discovery provided by the state of Indiana. So if you did give it to, we're giving you the, the option to say, you did give it to us on such and such date and let us go look, but we can't find it. So if you could help us out on that or let us know why we don't have it. All right, so in that certified letter, the defense requested a determination if said evidence exists, and if so, to determine if that evidence has been turned over to the defense as they were not able to locate it. In other words, the defense was seeking clarity as to whether the prosecution had turned over certain evidence or whether said evidence even exists. Number 6. The state of Indiana did not respond to the letter, but rather sent one e-discovery strand which contained a small portion of that evidence requested, including certain videotaped interviews that have never been turned over involving people integral to the timeline. Interesting. Videotaped interviews never turned over. The state of Indiana turned over these pieces of evidence more than 14 months late, pursuant to the local rule, without explanation. So just out of the blue, here you go. Pursuant to the local rule, the defense is not required to make specific requests of any evidence, as the state of Indiana is required to turn over all relevant items. Yet, without making the specific requests, it appears that the defense would never have received these most recent pieces of evidence, i.e., the videotaped interviews of certain witnesses. 10. The frustration from the defense is that this is not the first time that the defense has had to make specific requests for specific evidence that the state has failed to turn over to the defense. 11. Because law enforcement and the prosecution are in total control of what evidence is ultimately turned over to the defense has no choice but to hope that the state of Indiana turns over all relevant evidence, especially exculpatory evidence. They have a duty to turn over all evidence, including exculpatory evidence, all relevant evidence, I should say. All right, so the defense simply does not have the luxury of knowing what relevant or exculpatory evidence the state possesses and has turned over versus what relevant exculpatory evidence that the state of Indiana possesses but has failed to turn over. So we know they've done it once. What other things are they hiding? Number 12. Over the course of this case, the defense has learned of certain evidence referenced in other discovered documents or mentioned from other sources or from exercising common sense that has caused the defense, to believe that said evidence does exist, but that the prosecution has failed to turn over said evidence to the defense, and that the defense later determined that the prosecution did in fact possess those items, but failed to turn over items over to the defense until requested to do so by the defense. I say the defense a lot in that question, or in that number. All right, so number 13. The history of the prosecutor failing to turn over all relevant evidence to the defense has caused great concern to the defense, and I would be concerned too, especially if I was the defendant. Or how many of the people who are in court with their court lingo going, they say defendant and juror, and it's, yeah, anyways, the Murdoch trial. What's his face did that? Judge Newman did that. Defendant and juror. It's hard to say. Anyways, sorry. I digress. Over the course of this case, number 14, many of the items that the state of Indiana has failed to prove to the defense in a timely manner are what the defense would label as major pieces of evidence. They would go even as far as to say that some of it is exculpatory evidence. So 15, many of the items that the state of Indiana failed to provide to the defense in a timely manner were only provided after the defense had specifically requested the items that it came to learn existed, but the state of Indiana had failed to turn over. Do you guys wonder if there's like a federal investigation into this case, into the, much like Karen Reed, and there's an investigation into the investigation of what happened that night. Do you guys think that maybe the feds could be looking into this, and maybe that's why the state is starting to turn things over that they didn't in the past? Because that doesn't make sense to me that they would do that, but I mean, it could be like they know now that the jig is up, so they gotta start turning stuff over. I don't know. It's just an assumption because I feel like that's happened in Karen Reed. All right, so number 15, not an assumption, just a observation that it could happen. I don't know. All right, so 15. Many of the items that the state of Indiana failed to provide to the defense in a timely manner were only provided after the defense had specifically requested the items, came to learn it exists, but the state of Indiana had failed to turn over. 16. For example, one of the more important pieces of evidence in this case is the data retrieved from the phone found at the scene where the victims were found, as this piece of evidence contains data concerning down the hill video and rather important information. I bet you, yeah, if they kept that from, sorry, my eyelashes. If they kept that from the defense and there's information on there that could lead to somebody else, that maybe the girls were talking to somebody, maybe somebody lured them down there. I don't know. Before, I mean, like way before the down the hill guy, like somebody told them to be there that day and that's why they went. I don't know. That was always my assumption, like they were meeting somebody there. All right, so 17. This phone and the data contained on the phone has been available since 2017, yet the defense did not receive the data from that phone by the deadline of December 14th, 2022, as designated by local rule. Number 18, the defense, knowing that this evidence simply had to exist, finally sent an email to the prosecutor on June 17th, 2023, requesting the data from several phones, including the phone in question that belonged to Liberty German. Number 19, the state of Indiana did not provide, so the defense had to ask for it, which it should have just been handed over to them. Number 19, the state of Indiana did not provide the phone data from Liberty German's phone until September 8th, 2023, nearly 9 months after the state of Indiana should have turned over that evidence, and nearly 3 months after the defense specifically requested that evidence, even though the defense is not required to make a specific request for relevant evidence. So again, he's stressing we do not have the burden to go out and obtain that evidence. The evidence should be given to us by the prosecution, and that appears to have not only not happened, but it was delayed 9 months. All right, so number 20, most of the other items requested in that June 17th, 2023 email to the prosecution still to this day have not been turned over to the defense. This includes data, reports, and other information related to the images of the bridge purportedly taken on Liberty German's phone at 2:05 on February 13th, 2017, as well as an image of Abigail Williams walking on the bridge purportedly taken on Liberty German's phone at 2:07 p.m., both purportedly sent through Snapchat. So these images have yet to be given to the defense. Even though we know they're out there. All right, so number 21. The week of August 5th, 2023, the defense took several depositions. At the conclusion of that week, it became clear to the prosecution that the defense was pursuing information concerning certain Odinists that had been investigated by 3 law enforcement officers, Todd Click, Greg Ferenczi, and Kevin Murphy. And that's what I'm saying. Like, maybe there's a federal probe into these guys now because of the way that they handled this case. You know, if I were them, I'd be worried. I'd be worried if I was an officer who was crooked in any of these towns now, because people like me, people like Turtle Boy. I mean, I'm not saying I'm anywhere near Turtle Boy, but I'm just saying, like, people like us who are on the, who have a platform to talk about these things aren't going to let it go away. And that's why we need to do our part here. All right, so 22, on or about September 8th, 2023, nearly a month after said depositions, the prosecutor provided a daunting amount of newly discovered evidence, including a letter from Todd Click's lawyer discussing Click's concerns, essentially that the prosecution might be unaware of law enforcement's investigation into Brad Holder, Patrick Westfall, Elvis Fields, and others. So Todd Click had his lawyer send to the prosecution. Oh, wait, no. To the defense. Discovered evidence. Who got the letter? The prosecutor provided a daunting amount of newly discovered evidence, including a letter. So the prosecutor had a letter from Todd Click talking about how the prosecution might be unaware of law enforcement's investigation into them. So it was a letter from Click's lawyer telling prosecution, like, hey, you should go look at these guys here and others. Click believed that were likely involved in the unalivings. This letter and its contents were highly exculpatory for Richard Allen. 23. Upon receiving this missing evidence, the defense was surprised/shocked to learn that on May 1st, 2023, the prosecutor's office signed for the Todd Click letter and the exculpatory evidence and information contained in that letter, yet failed to alert the defense as to the existence of this exculpatory discovery until after the prosecutor knew for certain that the defense would definitely be calling Todd Click in for a future deposition. That is garbage. I hate that dishonesty. All right, so at which point in time the defense would most assuredly learn the existence of that exculpatory evidence. So they were going to hold on to that little nugget of information until they were going to hold on to it forever, but they got Todd Click coming for depositions, and you know that he knows, so you have to turn that exculpatory evidence over. All right, my eyes. What's a 24. Right? Did I finish that? No. So McLeland did not turn over the letter, and exculpatory material to the defense until September 8th, 2023. It took McLeland 131 days to turn over that exculpatory evidence, and it was only turned over after McLeland knew that the defense would ultimately find out that it was exculpatory evidence. So we only got it then. Number 24. The prosecutor offered no explanation whatsoever as to why he had held on to the exculpatory evidence for several months and only provided it to the defense once it became obvious that the defense would learn of the existence of that exculpatory evidence. The prosecutor had no explanation as to why he didn't turn it over. Number 25. Certainly, the defense would have been much further ahead in their defense of Richard Allen had the prosecutor turned over the Click information in a timely manner. Certainly, the defense would have been even more prepared for the August depositions had the prosecutor turned over that exculpatory evidence. 26. Between September 8th, 2023 and October 6th, 2023, approximately 90 days before the January 2024 trial dates that had been set, the state of Indiana dumped 14 hard drives, 5 flash drives, 1 disk, and a certain e-discovery on the defense, including several videotaped interviews of third-party suspects that the defense had focused on when deposing law enforcement in early August 2023. 27. The state of Indiana provided no explanation whatsoever why they had not turned over to the defense this massive amount of evidence, exculpatory or not, 9 months later than required under the local rule and a month after the prosecution learned that the defense was pursuing a defense that certain third parties were involved in the unalivings. Much of the late discovered missing evidence pertained to the focus of law enforcement on certain suspects involved in Odinism. Interesting that much of the discovery that was missing pertained to Odinism. Interesting. All right, so number 28, it was apparent that had the defense not alerted the state of Indiana as to their strategy to pursue the Odinist angle in defending their client, and therefore the likelihood that the defense would talk to Todd Click, who would reveal the existence of the letter, it is highly likely that the prosecutor would never have turned over that exculpatory evidence to the defense. I kind of agree with that. Number 29, the very last discovered item that the defense received before the prosecutor requested that the defense be kicked off the case. So the very last discovery they got before they were kicked off the case by the judge and the prosecutor. Geofencing evidence that the defense believes was received on October 6th, 2023. It was the last discovery they got. Geofencing evidence. Number 30, this geofencing evidence was received nearly 10 months after the state was required to turn it over and contained what appeared to be highly exculpatory evidence concerning a variety of important matters, including the phone numbers of multiple people who appear to have either been at the crime scene or within 60 yards to 100 yards of the crime scene during the very times when the victims were purportedly being unalived, according to the state's timeline provided in the probable cause affidavit. So in this late discovery, number 31, the defense found a map prepared by someone, presumably law enforcement, that appears to track the movements of these people in and around the crime scene the afternoon of December 13th, 2017, including between 3:02 p.m. and 3:27 p.m. at or near the location within 60 to 100 yards of where the bodies were ultimately found the following day. So I don't know if you know anything about geofencing. I'm not an expert, but it basically, because your phones and there's like master data in the cloud. And our phones, because they like ping in certain places all the time, they can kind of like get a sense, a geofence, a fence around a certain area as to what cell phones were pinging off, towers and what apps were being run in those areas, and they can find out all that information. And they can pinpoint it down to an individual if they desired, so potentially. All right, so number 32. Since their return to Richard Allen's defense, Allen's attorneys have specifically requested via email February 26, 2024, that the state of Indiana provide all narrative reports related to the geofencing data, as well as all documents related to the geofencing data, but the state of Indiana so far has claimed that no such documents exist. 33. Again, the defense is at the mercy of the prosecutor's claims of the existence or non-existence of such evidence. So now they're saying the geofencing data doesn't exist? I don't know. Okay. Number 34, as it relates to the geofencing evidence, it would be shocking that law enforcement would take the time to put a map together tracking the movements of certain phones exactly in and around the crime scene between 12:39:54 p.m. and 5:49:06 p.m. on February 13th, 2017, but would then not follow up with the detailed narrative reports concerning the geofencing analysis of that data. So there's got to be a report somewhere about that geofence data. That's what we want. 35. Yet the prosecution claims no such geofencing reports exist. However, the defense has heard this type of answer from the prosecution in the past, only to learn that the prosecution's claims that documents did not exist weren't true, as he's already evidenced in multiple cases here, in multiple examples. So, A, within the last 2 weeks, the defense deposed the state's phone dump expert who presumably will be testifying concerning the data found on Liberty German's phone. So within the last 2 weeks, the defense deposed that expert. B, before that deposition, the defense had emailed the prosecution on February 26, 2024, seeking reports related to the phone dump of that particular phone in order to prepare for said deposition. C, the prosecution responded to the defense claiming that there were no reports related to the phone dump from the expert. That is bull. How are they an expert if they're not providing a report back so that it could be put into evidence? That makes no sense. D, when the deposition minutes before the deposition began, the prosecutor handed over 2 to 3 pages of notes that the state's phone dump expert had made, providing the defense zero time to review as part of its preparation for the deposition and providing no opportunity for the defense to meet with its own technology expert in order to learn what questions we would need to ask. Like, what are the wise questions to ask this expert? That's bold. That's bold. E, the prosecutor handed over these notes without explanation and with no apparent reasons as to why the prosecutor had previously told the defense that no such documents exist, when in fact they did. F, the prosecutor's denial of the existence of certain documents regarding the phone dump before the deposition, followed by the unexplained production of certain documents within minutes of the deposition, sadly, was not surprising, but highlights once again the less than forthright style in which the prosecution has been turning over evidence to the defense dating back to the beginning of the case. 36. My brain's looking at it, it just said 6. My brain and my tongue don't do the same things sometimes. Furthermore, because of the lack of candor concerning the existence or non-existence of certain evidence, the defense cannot be sure whether certain documentation exists concerning geofencing analysis, even though the prosecution is claiming that no such documentation exists. Number 37, since rejoining the case. So now that we're back on the case, the defense has sought out the names of the geofencing experts who analyzed the geofencing evidence for purposes of preparing for depositions to determine if the state's expert has an explanation as to why the geofencing evidence displays what appears to be extremely exculpatory evidence of people walking in and around the crime scene during times when law enforcement is claiming that the unalivings were taking place. So they have a bunch of people's cell phones apparently walking in and around the crime scene throughout that entire timeline. So were those individuals looked at? Were they questioned? Claiming that okay, so at first, the prosecutor refused to provide the names of his experts, but then told the defense he would ask his investigator. 38. Again, specifically, someone prepared a map which tracked the February 13th, 2017 afternoon movements of multiple phones in and around the my Hungarians keeps calling me. Sorry, where was I? I lost my train of thought. Again, I'll just start from the beginning. Specifically, someone prepared a map which tracked the February 13th, 2017 afternoon movements of multiple phones in and around the place where the victims were ultimately found the following day. Particularly, some of these movements appear to have occurred between 3:02 p.m. and 3:27 p.m., either at the scene where the victims were ultimately found on February 14th or within 60 to 100 yards from the site, and none of the phones or people associated with the phones have any affiliation with Richard Allen. Bam! Mic drop. your your narrative of what happened is wrong. So we already know that. We picked that apart now. Number 39. Following the request for the identity of the geofencing experts, the prosecution claimed that he had no idea who analyzed the geofencing data, but then the state of Indiana provided the names of 4 people that may be called as experts for the state witnesses on geofencing. Number 40. Nowhere in discovery has the defense located any narrative report or other documentation or analysis of the geofencing data from any of the 4 identified state geofencing experts. So you've got 4 experts that are supposed to be testifying, and not a one of them has given you a report, supposedly. Number 41. Nowhere in discovery has the defense found any documentation negating the defense's analysis that the geofencing evidence shows multiple people were found in and around the crime scene at the time when law enforcement claims the unalivings were occurring. Number 42. Additionally, the defense has reviewed all discovery provided by the state of Indiana and has not yet found a single interview of any of the people whose phones, according to the geofencing data, were found the afternoon of February 13th, 2024, moving in or around the location where the bodies were ultimately found the following day at times when the unalivings would have taken place, according to law enforcement, according to their timelines. So number 43, the defense did locate very limited background information concerning one of the owners of one of the phones, but did not locate any narrative reports, interviews, or notes concerning the owner of the phone. Number 44, it would be shocking if the owners of these phones were not interviewed when their movements were tracked and then replicated on a map depicting their movements around the crime scene based upon geofencing coordinates. Yet the defense has not located any interviews of the owners of these phones. Number 45. The defense has located no information or interviews contained in any investigative documents concerning any other person or people whose phone numbers are identified on the 13th of February as walking in or around the same area where the victims were ultimately located that day. So no interviews have been located or investigative documents. So it appears that law enforcement didn't even look at them from what we have now, because we have nothing. All right. So maybe they did, but we didn't get it. 46. Again, someone in law enforcement summarized those movements by replicating them on a map, yet no narrative report can be found to explain why law enforcement reduced the movements to a map of the multiple people using multiple phones at or near the crime scene at the time that the unalivings were purportedly committed. 47. While it is possible that the geofencing is not what it appears to be, or perhaps was later debunked in some document that has not been turned over to the defense has found no documentation that dispels that the geofencing appears to be highly exculpatory in nature. The defense is attempting to verify what the geofencing evidence appears to show, and based upon the map that tracks the movements of multiple people, to verify what law enforcement is also apparently believes the geofencing coordinates show. Number 48. After the debacle involving the identity of the Purdue professor, the one who said that the crime scene, after reviewing photos of the crime scene, had Odinist ties, but the prosecution said that he said the exact opposite, that it didn't have some kind of Odinist angle going on in that they should be looking in that direction. They denied it just outright. So after that debacle, the defense has no faith at all that the prosecution will produce evidence such as geofencing analysis as required under Local Rule 08 CR 00-018 49, as detailed in the Franks Memorandum filed September 18th, 2023, as well as the defendant's additional Franks Notice filed October 3, 2023. Since August 10th, 2023, the defendant had asked the prosecutor to identify the Purdue professor whose findings thwarted investigative efforts to look into Odinism as being involved in the unalivings. 50. According to Sergeant Jerry Holman, the Purdue professor had reviewed the arrangements of certain sticks left at the crime scene and concluded that the sticks found on the girls at the crime scene, according to Holman, did not represent Odinism or any type of cult worshipping or any type of group that would have committed the crime. My dog's going to be up and begging for food now. It's annoying. He gets, his stomach tells him he's hungry before dinner time. Well, way before. Alright, or he might have to go out. Do you have to go potty? I'm going to have to pause here just for a moment. I will be right back. Please don't leave. That's why I really wanted to go live on this, but because I'm rushing my dog out to go potty like every hour or so, I didn't want to leave you guys hanging. So at least you can like fast forward, watch it, pause me, go do something else, and then come back and you can fast forward through this part. So, all right. I'll be right back. All right. Sorry about that. My dog feels so bad for him. Said it on other streams. He's got pancreatitis, so he gets flare-ups every now and then, and like food upsets his stomach. He has a hard time digesting his food, and he just got over like a bout of issues, and now he's drinking a ton of water and going to the bathroom a lot. So just kind of keeping an eye on him and making sure that he gets potty breaks frequently too. So hold on, my thing is caught here. All right, that's better. I needed to straighten out my desk. All right, so where are we? Modernism. According to Holman, Odinism. Did I read this one? I don't think so. Number 50, according to Sergeant Holman, the Purdue professor had reviewed. Come here, Dex. Come here. It's not time for food. Come. Sit down. Come lay down. He's just staring at me and drooling. I think, but I want to eat. All right. So, sorry. No more distractions. Although my boyfriend is going to be home soon, probably, and they're going to all go crazy, and you'll hear them go. My one dog, Abby. I'm going to have to post a picture of my dogs for you guys, just so you can see them. My female German Shepherd, Abby, sounds like Chewbacca when she's really excited. She like does these weird noises, and we call her a Wookiee sometimes. So it's funny. She does that when anybody comes in the door. She gets all excited. All right. So according to, I feel like I'm crooked again here. According to Sergeant Jerry Holman, the Purdue professor had reviewed the arrangement of certain sticks left at the crime scene and concluded that the sticks found on the girls at the crime scene, according to Holman, did not represent Odinism or any type of cult worshiping or any type of group that committed the crime. That's according to Holman's deposition. 51, however, after his deposition, the defense sought the identity of this Purdue professor who altered the way that the case was investigated. No one from the prosecution or law enforcement claimed that they could remember this Purdue professor's name. They all just suddenly forgot it, all of them, and couldn't find their notes on it or whatever. I don't believe that. So 52, after the defense made several requests from the prosecutor to identify the Purdue professor for purposes of conducting a deposition, the prosecutor sent an email to the defense on September 6th, 2023 that read, quote, as stated before, we are trying to identify the Purdue professor, but no luck yet. Detective Holman has reached out to the FBI and Purdue and has not gotten a response yet. We will continue our endeavors, but may not be able to identify him or her. Him or her. Like, you don't even know if it was a female or a male you spoke with. Okay. It almost sounds made up. Like, we have this person who told us this one thing, it's a tip, and it's totally legit, but we can't find them, and we don't remember them, and we can't tell you how to get to them. It does not sound real. All right, so 53. This response from the prosecutor seemed utterly preposterous. It had been nearly a month since the defense first made its request for the prosecutor to identify the Purdue professor, and the state police, with all the resources at its disposal, claims that it was unable to identify the Purdue professor, even indicating that they may not ever be able to identify the Purdue professor that shouldn't be there. The prosecutor's email seemed implausible. Yes, it did. To me, it does. Number 54. The mere identity of the Purdue professor is considered discovery that should have been turned over to the defense. His name and reports should have been provided to the defense no later than December 14th, 2022, according to local rule that was referenced above. So yet, on September 6th, 2023, the prosecutor told the defense that Jerry Holman and the vast resources of the Indiana State Police could not figure out who this professor was, nor did the prosecutor turn over any of the Purdue professor's reports. Nothing to see here. This person didn't exist because it doesn't fit our narrative, basically. So number 55, however, since getting back on the case, the defense has learned that Jerry Holman did in fact learn the identity of the professor, Jerry Turco, on August 12th, 2023, through the Purdue Police Department, and Turco's identity was confirmed a few days later by other law enforcement. Holman even had possession of Turco's report, which contradicted Holman's August sworn testimony during this same time frame. It's pretty damning for Holman. I wonder if there's going to be any kind of repercussions for law enforcement for lying. 56. That's why I'm saying, like, there needs to be a federal investigation into this whole thing, because the feds need to come and take down people like Holman who are lying on the stand and purposely hiding information, if that is in fact what is happening. All right, so 56. The information contained in paragraph 55 above came directly from Jerry Holman's own report, the Turco report. Where was I? That he prepared on September 22nd. Holman's report was not made available to the defense until February of this year. 57. Holman's September 22nd report exposed the following concerning the state of Indiana's intentional violation of the discovery order due to their attempt to hide the identity of an exculpatory witness. So A, during the month of August 2023, the defense made multiple requests for the state of Indiana to identify the Purdue professor who, according to Jerry Holman and Tony Liggett, altered the way the case was investigated. Certainly did. Told you not to look here, but look over here. That's exactly what the letter is, or the conclusions that they supposedly came up with do. It allows them to look the other way. B. By mid-August 2023, Holman knew the identity of the Purdue professor, yet throughout all of August and September, McLeland told the defense on multiple occasions that Holman and or law enforcement could not figure out the identity of the Purdue professor. McLeland, September 6, 2023, email to the defense detailing Holman's inability to identify the Purdue professor was clearly not true. Obviously, McLeland lied. Intentionally, or did he provide misinformation? You guys tell me what you think. D. After the filing of the Franks Memorandum on September 18th, Jerry Holman was forced to interview the Purdue professor before the professor learned that he was missing. Holman interviewed the professor the very next day, so the 19th. Wow, I didn't know that. All right, so Holman's September 22nd report memorializing his meeting with Turco is filled with multiple falsehoods and mischaracterizations concerning his conversation with Turco. In what appears to be an attempt to water down Turco's actual opinion that it was a given that someone was trying to replicate a Germanic runic script, Holman memorialized Turco's conclusions as inconclusive. But that's not so true, is it? Despite how Holman drafted his report, Turco's conclusions were not inconclusive whatsoever. Turco was clear that in his opinion, and that of a Harvard expert, the sticks found at the scene were an attempt to replicate a Germanic rune script. The only thing that Turco could not say for certain was the intended meaning of the persons who left the runic script at the crime scene. So the intended meaning of the person, like the only thing he couldn't be sure, like I know this looks like a blah blah, this looks like a whatever, but I can't be sure what that person actually intended is what he's saying. So Holman also attempted to deceive those reading his report when he, Holman, wrote in his report that Turco stated that no evidence or research indicated that those involved in Odinism practices ritualistic human sacrifices. Yikes. Okay, so Holman chose to not include Turco's actual words that the stick figures were pretty clearly runic and that he Turco could certainly imagine that this was somebody's idea, that when you do human sacrifices you carve runes. There are some poetic sources that would sort of support that idea of somebody might have come across. The scenario seemed entirely plausible to me, Turco tape. All right, so whereas Turco told Holman to his face that the people who placed these sticks on the girls clearly were attempting to create runes and that it was entirely plausible that the perpetrator would believe that after a human sacrifice they should carve runes. Holman attempted to deceive the reader of the report by implying that Turco totally disregarded the possibility of the involvement of human sacrifice. That is not what Turco said. Got it. Okay. So 58, Holman certainly understood that on August 10th, 2023, he, Holman, did not tell the truth under oath at his deposition. Oh, he understood. But sorry. I was like, did he admit that he didn't tell the truth? No, he just understood that he didn't tell the truth under deposition concerning the findings of the Purdue professor when he tried to hide the identity of the professor. While Holman was attempting to hide the identity of the Purdue professor, what Holman did not account for was that the Franks memorandum would be filed on September 18th, 2023, and the Franks memo would call out Holman and McLeland for claiming that they could not figure out the identity of the Purdue professor. That's amazing. Like, oh, you're not going to give it to us? We'll just put it in a public filing and then we'll call you out in front of everybody, letting them know that you're not doing your job. 59. Furthermore, McLeland never once contacted the defense and alerted them to the Purdue professor, or that the Purdue professor had been found. Number 60. Furthermore, McLeland has still never explained to the defense why he had sent an email to on September 6th claiming, oh, that was loud, sorry, rain. Furthermore, McLeland has still never explained to the defense why he has sent an email on September 6th claiming that the identity of the professor was still unknown when it was later revealed that Holman had known of the identity of the professor several weeks earlier. And I wouldn't be surprised if they knew of the professor the whole time. Additionally, McLeland never turned over the Purdue report until receiving an email from the defense requesting that he turn over the report. 62. McLeland finally turned over the Purdue report on October 4th at 9:43 p.m. via email, nearly 10 months after he was required to do so under local rules, and well over a month after Holman had received the report in mid-August. 63. The Purdue report that the prosecutor finally turned over to defense further exposed the lack of veracity of Liggett's and Holman's August 2023 deposition testimony, which further explained why Holman tried to hide the identity of the the Purdue professor. I merged the two words together in my mind. And the contents of his 2017 report. Number 64. In addition to those discovery violations already identified, the state of Indiana I mean, there's a lot. The state of Indiana has also failed to produce other evidence that the defense has had to either pursue on its own or make a specific request from the prosecution. Some of this evidence includes, but is not limited to, the following. A. The faked crime scene image found on Brad Holder's Facebook page. The defense had to travel to Georgia to retrieve a copy of that image. To this day, the state of Indiana has not turned over a copy of said faked crime scene image, while having to admit in deposition testimony that it is real and was found on Brad Holder's Facebook page within weeks of the unalivings. B. Video of a ritual in Fort Wayne involving Brad Holder and Patrick Westfall, in which Westfall can be seen marking a tree using his hand. No. Go lay down. Come on. Lay down. Lay down. It's a battle of wits. He's like, it's an hour before dinner, feed me. Right, so after finding references to this ritualistic video in an email from Detective Greg Ferenczi to Tony Liggett, the defense had to ask for that video as the prosecution had not yet turned the video over to the defense. The video was finally received on or about September 8th, around 10 months after the prosecutor had was required to turn it over. C. We got video of Elvis Field's interview, which was not turned over until September 8th. Video of Johnny Messer interview, not turned over until September 8th. Video of Rod Abrams, same. And video of Ned Smith, same. 65. These attempts at concealing evidence at the hands of Holman and the prosecution detailed in this motion provides the McLeland provides the underpinnings to support the defense position that law enforcement and the prosecution continue to hide evidence from the defense and do so without care or concern of any consequences from this court. Nicely said. All right. So 66. The defense recently filed its motion for early trial for several reasons, including concern for their client's safety and mental and physical health. So we just found out last week they filed, I believe it was on the 6th, and then Friday, no wait, was it yesterday? Yesterday, my days blur together, guys. It was yesterday that Judge Gull issued her order. Where'd my water go? Here it is. She issued the order for the trial date to be set May 13th, which is right about 70 days from when the motion for 70-day trial was put in place. So that just happened. And then, so they're telling us they did it for several reasons. The biggest concern that the defense has concerning the early trial request is the prosecution's continued violation of the discovery rules. The defense would therefore request the court to compel the state of Indiana and law enforcement to turn over all relevant evidence in its possession. Again, as the defense does not have the luxury of knowing what is in the state's possession, the defense can only specifically request discovery that the defense believes exists based upon a common sense understanding of the evidence that they currently have in their possession and the evidence that should exist as an extension of the evidence that the defense already has. 69. The defense is requesting the court to compel the state of Indiana to turn over the defense by no later than Monday, March 18th. That's next week, guys. All evidence that it may have in its possession but has failed to turn over, including the following. A. All reports that detail how certain videos that should have been found on a hard drive labeled Delphi DVR Original were purportedly deleted between February 13th through the 20th, including deleted videotaped interviews of Brad Holder and Patrick Westfall. This would include any reports that detail how the erased videos were discovered, what attempts were made to retrieve the erased videos, an explanation for how the deleted videos were erased, and any attempts to contact the subjects of the erased interviews for a re-interview. Interesting. So do we have all the Brad Holder, Patrick Westphal videos, interviews? I thought they were erased or taped over, but now we maybe do have them. I know they were re-interviewed, but it sounds like this is the first interview that they got. So, by all reports that detail how certain audio is missing in certain videos found on a hard drive labeled Delphi DVR original, in which the video is present but the audio is not. The defense would further request all reports that detail why there is not audio, what efforts have been made to retrieve the audio, and any attempts at recreating the audio by re-interviewing those seen but not heard on the video. The identity of all persons whose interviews were erased as detailed in paragraph 69A above, and also the identity of all persons who are viewed in all video in which there is no audio as detailed in paragraph 69 above. Similarly, the state of Indiana provided hard drive Delphi DVR drive 1 export in which the state of Indiana claims that, quote, there is no detectable audio on the original drive from which the duplicate was made, end quote. The defense requests the court to compel the state of Indiana to identify all persons viewed on this hard drive in which no audio is available, as well as a synopsis of what was said on the missing audio. On hard drive Delphi DVR drive 1 export, it appears that a sketch artist made with a lady and then sketched out an image of a male. The sketch artist met with a lady and sketched out an image of the male. The defense has never seen the sketch, nor has the prosecutor produced this sketch to the defense. The defense requests the name of the female who appears to provide the information that resulted in the sketch, as well as all documents. So there's another sketch out there, guys. Yet another sketch than the two that we've already had. So there's another sketch that's been hidden from us. That's probably the actual unaliver. I don't know, maybe. The defense requests the name of the female who appears to provide the information that resulted in the sketch, as well as all documents of the sketch artist that the defense has seen other sketch artists produce in other sketches, and the substance of the conversation between the sketch artist and the lady providing the information, and all law enforcement reports detailing why law enforcement asked this witness to provide information for a sketch artist. Furthermore, the defense requests the court to compel the state of Indiana to produce the sketch itself, if you can. It doesn't say that. I said if you can, but they can't really. They've been not able to turn over much. All right, so continuing on. All of Derek German's law enforcement interviews, including, so Derek German, is that the grandpa? Or, I didn't know that was his name. I don't know who Derek German is. Anybody in the chat know? Where's my phone? Can't find it. Alright, let me open up a Google tab. I don't know who Derek German is. I know Patty. Oops, go to Google. What's his name? Derek German. All right. Who is Derek German? No. Okay. It's this guy, whoever that guy is, but it's not. I think it's, you know what? Let me write Delphi. That's probably what I did wrong. And I don't want images now. Who is he? Someone who was incarcerated? Derek German. Delphi. This is some Reddit post. Who is he though? Early YouTube video. Derek German was currently in the same prison with Richard Allen. Obviously related to Liberty German, but who is he to her? I don't know. I might have to look into him because let's see what this says. This is some Delphi to the investigation here. Sorry, I don't like going off script. Like I don't like doing things on plan, but I'm gonna do a find. They spelled his name wrong then on purpose? Did they spell his name wrong on purpose? It's Libby's father. Okay. But aren't the people that we see here are Becky and Mike Patty, who are her grandparents. So Derek German is Libby's father, who we don't know how much of he was in the picture. Because Libby's grandmother and primary caregiver was Becky. Go lay down, Dexter. It's not time. This is a whole article about Derek. I might have to look at this. There go the dogs. That's a whole article about Derek German. So I might do maybe a show on him or something. I'm not sure. So anyways, all of Derek German's law enforcement interviews, including audio, video, and or notes reports memorializing any law enforcement interview. If he was never interviewed, the defense would ask for confirmation of that. So why didn't you if you didn't interview her dad, why not? All right, so for purposes of establishing a timeline, all of Kelsey German, that's her older sister German's phones, or her phone dump of all phones attributable to Kelsey German, if her phone was never collected, the defense would request confirmation of this. Furthermore, every law enforcement interview of Kelsey German, including video, audio, and or notes reports memorializing any law enforcement interviews. If she was never interviewed, the defense would ask for confirmation on that. All of Cody Patty's phone dumps. I don't know who that is either, but maybe an uncle perhaps, of all phones attributable to Cody. So this is what they want. If his phone was never collected, the defense would request confirmation of this fact. Furthermore, of every law enforcement interview of Cody Patty, including video, audio, and or notes reports memorializing any law enforcement interviews. If he was never interviewed, the defense would ask for confirmation of that. There are two images that exist, but which the state of Indiana has not turned over to the defense. Thanks, dog. Just threw a bone on the floor really loud. Those images can be found on the internet, with at least one of those images seemingly adopted by law enforcement as being legitimate, as it has been utilized by law enforcement in various media appearances, including a 2019 press conference. We are talking about the photo of Abby Williams walking on the bridge, purportedly taken at 2:07 p.m. on 2/13/2017. Attributable to being sent via Snapchat from Liberty German's phone. Also an image of the Monon High Bridge purportedly taken at 2:05 p.m. Also attributable to being sent via Snapchat from Liberty German's phone. Related to those items, the defense would ask the court to compel the state of Indiana for the following that so far has not been produced: interviews or reports of Kyle Smith or anyone else that received either or both images taken on the bridge. So that's the recipient of the images that Libby sent in Snapchat. All reports, analysis, and documentation detailing any information about the images purportedly taken at 2:05 p.m. and 2:07 and sent out via Snapchat. All reports, documentation, and analysis from Snapchat or any law enforcement agency dealing with the data confirming when those images were taken, where they were taken, and how they were distributed, including all reports related to the data and metadata. And you know they have that information. They're just hiding it. Any analysis related to those images that has been conducted by law enforcement agency or by any person or governmental or private entity that has worked with law enforcement. If the state of Indiana does not believe that the image of Abby walking on the bridge at 2:07 p.m. and of the bridge taken at 2:05 are discoverable because the state of Indiana does not claim that those images are relevant or reliable, then the defense requests confirmation of the same. Why wouldn't it be reliable? So then why should we rely on anything else from your data dump that you're saying? All reports and or documents, including phone dumps from any phone or electronic device that was believed to be possibly a phone or electronic device of either victim used near the Moden High Bridge or in an area that was geofenced near the Moden High Bridge and was identified as a victim phone, that is different than the phone found at the crime scene. So they're looking at any other phone that the girls may have had. Did they have another phone? Maybe Abby had a phone and law enforcement is holding on to that phone for some reason. I don't know. All emails between Professor Turco and any law enforcement officer from 2017 to present, all reports, documentation, notes, or any analysis of geofencing data related to this case, the identity of the person or persons presumably law enforcement that labeled the geofencing data, including labeling a second phone as geofence victim, that was not the phone belonging to Liberty German. So they did have another phone. They didn't give it over. The identity of the geofence victim from the phone that does not belong to Liberty German. Interesting. All right, so the identity of the person or persons, presumably law enforcement, that reduced the geofencing coordinates of multiple phones on February 13th between 12:39 and 5:49 to a map tracking the various phones on that date between those times. So they're assuming that law enforcement did this, and they're like, we want to see it. All interviews, reports, documents, or memorialization of interviews or of anyone whose phone was found through geofencing in or around the crime scene at the time that law enforcement is claiming that the unalivings took place, the afternoon of February 13th. All reports and all leak investigations not related to the Mitch Westerman leak investigations, including any reports made by Nick McLeland of content providers reaching out to him, content creators, I think they mean, reaching out to him, claiming that they were in possession of the leaked information, and which McLeland then ordered the content provider to delete the messages. So that involves the leak of the two photos. The defense further requests that the state of Indiana be sanctioned for the variety of discovery violations detailed in the document. Specifically, the defense requests that should any violations result in the need for a continuance of the early trial in order to evaluate late discovered evidence, that the time be applied against the state of Indiana and not Richard Allen. Wherefore, the accused moves this court to compel the state of Indiana to provide all relevant evidence in its possession to the defense, including all specific requests made in paragraph 69 herein. And that is signed by Andrew Baldwin, and certificate of service. It was, I'm sure, delivered to all parties involved. So there you have it. That is the motion to compel and to request sanctions of the district attorney's office, specifically Nick McLeland, who has not been turning discovery over potentially or possibly on purpose. So what do you guys think? Do you think he just lost the discovery and all of a sudden found it, or do you think that he's been holding on to it? Let me know in the chat below, or in the comments below. Please don't forget to like and subscribe to this, subscribe to my channel, like this video, and I will see you next time. Take care.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.